Hello, welcome to the first episode of my professional development series covering the 2020 legislative session debrief as well as some education law trends. This is going to be a 10 episode series, so we'll try to keep these about a half hour apiece and go over release weekly about over 10 weeks. So doing this through my professional corporation, and the information about my professional corporation is on the slide that you see here. My website's there and my contact information. So I look forward to sharing information with you over these 10 episodes. My objective is to help you navigate and provide a compass to you through the various issues that were coming out of the Indiana General Assembly session. I also intend to provide you with some insights into some other issues that are currently going on with education law. The other thing that I'm doing in conjunction with this series is doing something I'm calling e-office hours. And these are intended to be an opportunity for engagement because obviously the professional development is recorded, does not have interaction, and this gives folks an opportunity to ask questions and have discussion with each other even about some of the topics that we're covering. This is something that is at no additional cost to the clients that I work with. And even if you don't work with me as a client and you want to participate, you have that opportunity if you register in that regard. So if you can do that on my website if you haven't already done so, and you can also just contact me and I can tell you more about that. So expect to hear more about that soon. Obviously the objective of this topic is to give you a comprehensive review of the State House and to address the legislation that came from the Indiana General Assembly. No, from my video, I'm not literally on the south steps or the south lawn of the State House, but we'll be mixing it up with some virtual background depending upon the topic that we are covering. Today, for this first episode, we are covering the laws that are currently on the books. So I've labeled it effective upon passage. So whenever you see a bill and each section at the very beginning has a label as to when that law were to go into effect. And the default is usually July 1st after the session ends. However, often what you'll see is that there'll be a designation that the law will say effective upon passage. And that means that once the governor signs it, the law is on the books and you need to be in compliance with it. You'll also things like, you'll see things that the law might be even retroactive. Or have another date of compliance. But the objective of today is to give folks an idea of what they need to be in compliance with now. So that's where they get started if they have the opportunity. A few disclaimers that I like to provide in my professional development and as applied to this particular topic. The first one is that my audience for this professional development is a broad one. Includes all different types of education leaders, and it also includes attorneys. So I'm going to provide practical guidance for everyone, but we'll be towing the line between providing sort of general guidance as well as covering more technical issues that some of the attorneys might be able to get quite a bit of use out of. So you'll see both a general review of the provisions of the laws that pass, as well as some of the specific language that you might actually see in the statute. Also realize that the guidance is based upon what the current standards are. And just like everything, all law, it's subject to change. And so this is based upon the laws that are currently on the books. And so these statutes can be changed in future sessions. Courts could interpret them differently than they're being interpreted now. So just realize we're applying the current standards. Realize this is also not a comprehensive review of everything that's out there. Particularly, this is not a comprehensive review of all the education law issues that are out there at this time. So I'm only going to be covering very specific ones to complement the 2020 session. This does not cover any local regulation. So that means if you have an ordinance from your municipal entity where your organization is, you need to make sure you're in compliance with those. This also doesn't cover your internal policy, procedure, or guidelines. You need to make sure you're in compliance with everything that you have on your books for your organization. This may prompt you to change some of that, however. The bottom line is you need to make sure that you're in compliance with everything. And so the Indiana statute, the state statute, gives you a good start on that, but don't miss out on some of the other standards that apply to you. Thought it would be helpful, particularly in this episode, to give sort of a first table of contents view of the different legislation that we are covering. Some of these we're going to breeze over, and some we're not going to cover at all in depth. But we'll start off with the Senate bills, and the first one is Senate Enrolled Act 2, and that is in regards to school accountability. That's also referred to as the Hold Harmless legislation. This one is actually retroactive, so not only is it on the books now, but it's on the books effective in the past, and we'll cover that in depth. So the next one is SEA 273, and that is in regards to the Indiana Behavioral Health Commission. Well, I hope to get to that and address that, but that is particularly if your organization is concerned about behavioral health issues, that's something to watch out for. SEA 319 is the practitioner or accomplished practitioner license. This is also referred to as the PGP externship fix. So we'll cover that in some depth here today. SEA 346 is the Students with Disabilities law. Addresses some of the issues about state assessment accommodations and some other provisions. And some of this is on the books now. Some of this law is already there, is already in effect. So we'll cover those. Others we'll save for future episodes. SEA 398 is one of those potpourri various bills that you see. Has a lot of different stuff in it. One of the things that we'll actually cover in a future episode is the member youth organization mandate. But there are a few provisions in there that we'll cover today because they are effective now. And then to wrap up the review of the Senate laws is SEA 409, the employment of minors provision. And some of that law is effective as of April 1st. I'm not going to cover that all today. I just wanted, for those that address those issues in your community, wanted you to be aware of that there was some reform of that issue of the employment of minors. Next, we'll cover House laws, HEA, House Enrolled Act 1002. Got a fair amount of attention regarding decoupling of assessments from evaluations. Some of that we'll cover today, but most of it we'll cover in future episodes. 1003, we will definitely cover in depth through the series. We'll cover a few things to get it on your radar today. HEA 1065 as well as HEA 1066 are two of Jeff Thompson's various bills of legislation. Has a lot of stuff in it. We'll cover the items that are effective now. So you're aware of those. Others were saved for later. HEA 1082 has some various issues about higher education matters. I included in the materials so that you had that reference. We'll not cover it in depth and maybe at all today based upon how much we have time for. HEA 1113 is in regards to local government finance. This is DLGF's sort of annual bill. The only thing that goes into effect that's in effect now is a provision that only focuses on the city of Wabash. So I'm going to save that other broader issues for future episodes, but at least for today, I want you to be aware of the implication for the city of Wabash. HEA 1153 is some reform in regards to the governor's workforce cabinet and that addressing CTE, and should be able to address that today, at least briefly. HEA 1244 has to do with unemployment hearings and appeals, some significant reform to that process, and ironically, given the current economy that we're in, that might have some renewed relevance. So I'm not going to cover that in depth, but I do have in the materials, and certainly as you might get involved in more unemployment hearing issues, it is there for your reference to see what the updates are. HEA 1341 deals with students with disabilities, and there are a few items in there that are in effect now, and I will cover those briefly today. And then finally, something I'm not going to cover other than referencing it now is HEA 1372 has some insurance matters items in there. The only thing that's in effect now is a summer study provision in there. You see summer study provisions commonly included in commonly identified for effective upon passage, so that they can be assigned to summer study schedules. So we'll start off with the Senate laws. This is the Senate chamber, and so we'll start here. And as I referenced before, SEA 2 is the hold harmless legislation. This is a breakdown of the digest, the description from the General Assembly as to what this does. And I'll cover a few of these items in more depth. I think this got quite a bit of exposure, but the bottom line is that this is to address concerns about how the scores from the iLearn assessment are not going to negatively affect, at least immediately, schools and school corporations. So that's what the first several provisions do. Kind of allows a selection of what scores to be used, and then the consequences for school improvement don't apply for 18 and 19 or 19 and 20. And then the final provision is that relevant to our discussion is that it's not supposed to have a negative effect on the annual performance evaluation for a certificate employee, particularly a teacher. We'll break this down a little bit more in that if you are a school or a school corporation that actually liked your score and felt like this, the hold harmless would actually negatively affect you, you have a mechanism, and from my perception, some automatic mechanisms. These are 3 provisions that I've copied and pasted from the code that allow you to petition the state board to get a waiver from the hold harmless provisions. And the way that I read this language is that the state board really doesn't scrutinize that. Is that if you want the waiver from the hold harmless, you can get it. The other piece from SEA 2 that I already referenced briefly was in regards to the proportionate increase, the evaluation, and just realize this is the language that comes directly from their code, and it has to do with how you're supposed to deal with evaluations, given that one of the factors isn't assessment. So if the iLearn program scores or category are not used in the teachers or the certificated employees annual performance evaluation, the weight of all the measures used in the certificated employee's annual performance evaluation must be proportionally increased to replace the measures. So you got to do that calculation. Next one, next law we'll cover is 319, and this is that externship 15-point PGP issue that has essentially been fixed through this provision. The new law provides that 15 of the PGP points are required to renew a practitioner license or accomplished practitioner license may be obtained through one or more of the certain professional development experiences. So as many of you are probably aware, that was a mandate as of the 2019 session, and now that's been rolled back and it's now permissive. And it also does some other things, but what I found interesting was you don't even see the word externship in the law now. So this is the actual language from the new code provision, and you see that first phrase, the externship language has been stricken and replaced with this language of working for or with a local company in a capacity that includes an understanding of the current and future economic needs of the company and community, and a process to disseminate the information to students. The next issue from 319 is that there's a suggestion of utilizing other methods for obtaining these now permissive PGP opportunities. These are the ones that were suggested by the legislators. On the top of that list is robotics. And one thing that I've seen is that the legislators like to encourage robotics quite a bit. So I guess not surprising, but it was just an observation that I saw a lot of references to encouragement of the robotics industry in this past session. The next law that I'll address, just for purposes of pointing out the provisions that are now on the books, now in effect, and I'll cover other issues of 347, 346 in a later episode, have to do with one is that a member of the state board now has to be a special ed teacher or a special ed director. If you know of someone that might fit the bill and might like to be on the state board and have some influence there, now's your opportunity to get them plugged in. It also establishes a task force to review accommodations provided for statewide assessments, and that's what a lot of this bill has to do with is accommodations for state assessments. And then the possibility of separating the academic standard of reading comprehension into a separate reading academic standard and a comprehensive academic standard. A final report and recommendations from this task force needs to be provided by November 1st, but the law is now in effect to get the task force rolling. So that gets us through the Senate for the major bills I wanted to cover for today. Now we move over to the House chamber, and we'll start with 1002. Again, this is the decoupling legislation, which I will cover in a future episode. But for today, I want to make sure that you're aware that the State Board of Ed has some responsibility immediately to develop some emergency rules to implement the legislation to effectively decouple assessments from evaluations. You'll see throughout the State Board of Ed has quite a bit of relevance for these laws that go into effect immediately. That's a common theme that we see. Next, covering 1003. 1003, as I referenced before, I will cover quite a bit in a future episode, and probably will cover it in a standalone episode because it's so important. There's so much stuff in it. One issue that I'll at least get on your radar that doesn't go into effect until July 1st, but wanted you to be thinking about it, because it's been something that folks have been trying to address for a while, is deregulating employee training. And now the State Board of Ed has the authority to streamline the process of trainings for school employees. So wanted you to be aware of that in case you want to get plugged in on that topic. And then more importantly for today, something that is in effect already is that the State Board has the authority to grant waivers for a variety and many statutes or rules. And legislators refer to this as the educator or academic freedom legislation. Thought that was a interesting label of that, but the way that I think many of us have been working on this issue is that this is deregulation. This is hopefully an effective tool that school leaders can use to identify regulations and laws that burden them, and ask for the State Board to break the chains of that regulation. And we'll be addressing that in more depth in a future episode. But for today, wanted you to be thinking about what you might like to be involved with, because it allows a school or a group of schools to come together and ask for the State Board to waive regs and statutes that do one of the following things: improve student performance and outcomes, offer the applicant flexibility in the administration of educational programs, or improve the efficiency of school operations, promote innovative educational approaches to student learning, advance the mission or purpose of school or group of schools. And this, again, coming back to the State Board, gives the State Board the authority to adopt rules to implement this process. So be thinking about this. Now we're going to jump to 1065. This is one of Representative Jeff Thompson's various bills. This one's on tax matters. Has a variety of issues in it. I just included the ones you see on this slide here just for your reference. If you're in Hamilton County, you'll find the last one of relevance to you, because while you don't see Hamilton County in the language, it's effectively targeting or prepared for Hamilton County to address some of their lit issues for the municipalities in that county. One of the bigger things that hopefully it's perceived as a welcome thing is that this language is been stricken and is no longer in the code, meaning that you no longer have a CTE program cap for funding. So to the extent that that has been a barrier or concern for you, there's no longer a cap there. Next is something that got quite a bit of attention, maybe the most attention from the entire session on any topic, is at least at the end of session, is the issue of sharing of revenue between school corporations and charter schools. The first provision provides that a charter school can essentially say, yeah, we will share certain parts of our funds with a school corporation in some kind of joint effort. I think that was probably something could do before, but this is making it more explicit. Next item is the issue of what got the most attention on these topics is a permissive provision that allowed a school corporation to share referendum funds with a charter school, but it can't be a virtual charter school, and it has to be located in the school corporation attendance area. This is language that actually comes directly from the code, and I'm not sure got a lot of attention. This is a mandate in that if a school corporation is developing a resolution regarding a referendum to start the referendum process, it must indicate whether the proceeds in the school corporation's education fund collected from the tax levy will be used to provide distribution to the charter school or the charter schools, excluding the virtual school, and the amount that will be distributed to the particular charter school or the charter schools. So you have to include whether or not you're going to be sharing those funds in any referendum resolution that's adopted in the future. And it also provides that a school corporation can request a charter school for financial documentation to demonstrate financial need. Again, one of those things that they could have requested this with or without this language, but I guess it gives it a reference point if there's any question to it. Another issue that came out of 1065 was something that I know that some of the professional associations, particularly the School Boards Association, has been actively involved in, is the issue of having public school voice in residential TIF issues or TIF issues in general. On this issue, I think a lot of the controversy was about how much voice should schools have in these programs, and I think the end result here is that they are part of the process, but more about receiving information than having significant influence over the process. But it was a compromise nonetheless. So I've referenced this before, is that some of these various bills that you see, whether they're from Representative Thompson or Representative Baining or Representative Rotz, some of the legislators tend to use these various pieces of legislation as a vehicle to get a lot of stuff through, and that sometimes can benefit you and sometimes it can't, or it doesn't. So some people call them Christmas tree legislation or potpourri legislation, but they are a mechanism to get some legislation through. And again, sometimes you like it and sometimes you don't. But I don't see them going away, but it's definitely something that we have to watch out for. Representative Thompson's other version of that was 1066, has several provisions in it that we'll cover in future episodes. But two that I'll reference here is if you're an innovation network school, something to be aware of in terms of enrollment issues. That's provided in the second bullet point there. And then the third bullet point there has to do with how do you address seniority when you got a reorganized school corporation. This was, I think, specifically to address a situation in southern Indiana with a reorganized school corporation, but something to be mindful of if you have any reorganization. Next one to address here, we've now gone from the House and Senate bills that I wanted to make sure that we covered, and we're coming close to that 30-minute time that I'm trying to stay close to. But I'll just reference a few more of this legislation, a few more of these bills before we wrap up. 273 again creates this Indiana Behavioral Health Commission. It's a large group, but could be a really important mechanism to continue with behavioral health issues. And the most important thing for today is that it's on the books now, and there are various folks that are going to be plugged into this commission. And if you think of people that fit the bill, pun intended, under this provision, then now's your opportunity to see if you can get somebody on the list. So if you see somebody that is in one of these positions, the governor appoints most of them. So if you wanted to let me know, I could see what I could do. You can also, if you got a contact in the governor's office, you can also make sure that they are aware of your suggestion for filling these positions. Next is 398, one of these various bills, this one from Senator Rotz, and it has a lot of stuff in there, which I will reference. The only thing I'm going to reference today is realizing there's this legislative study committee piece that is effective immediately. 1082, I referenced this before in the table of contents review. These are the provisions you can review on your own time about higher ed matters. 1153 These are the updates to the workforce development cabinet provisions, and specifically to address early childhood and in regards to looking at a review of the educational system to align with employer needs. And so that these are just some of the updates to the workforce cabinet. Referenced this before as well. 1244, the unemployment hearing process changes, which could have renewed relevance for you. So here are the changes to that. I believe this is the final bill to cover, and just real briefly, this creates a requirement for the State Advisory Council on the education of children with disabilities to address the issue of informing former students of certain information to help them in the future. So that's what this 1341 does. So what I would like to do with these episodes when I wrap them up is just to provide you some practical items in a checklist form. So hopefully you'll see these towards the end of all the episodes that I'll wrap things up to give you things to do. First is, if you haven't already received it, you'll be getting a survey after each episode to provide some feedback, maybe ask some questions that will assist with the e-office hours. Also come up with your plan of how you're going to distribute these videos and the materials so that you take advantage of the information that you have access to. Make sure that when the information about the e-office hours comes out, that you get those on your calendar, and encourage you to participate. In regards to SEA 2, if you want a waiver from the hold harmless, they're not hard to get, but you have to ask for it. Also from SEA 2, make sure that you're incorporating the proportionate increase, given that the iLearn provisions are going to be taken out of the assessment provision for teachers. For SEA 319, your teachers may or may not, your employees may or may not be aware of that this PGP externship controversy is effectively now over, and they don't have that requirement anymore. SEA 346, if you know of a special ed educator that wants to be on the State Board of Ed, and you think that they would be a valuable addition, now is your opportunity to try to get them plugged in. If you have a suggestion, I'm happy to pass that along as well. In regards to HEA 1003, we'll cover that in more depth later, but please do be thinking about both the training piece and the waiver process with the State Board of Ed. For 1065, know that you can be planning in regards to the CTE program funds, given that it no longer has a cap. So plan accordingly on that. Also with 1065, for any future referenda resolution that you pass, it's got to have that additional language that's in there from the code about whether or not you're sharing revenue with charter schools. For 273, lots of opportunities to get plugged folks into the Indiana Behavioral Health Commission. So if you think somebody is good for that, make sure that you pass along that information. For 1244 on the unemployment process, it's on the horizon that we're going to have a lot more unemployment claims. So make sure you're aware of the changes in the process. And then an overall theme is that State Board of Ed is highly involved with at least the legislation that is effective upon passage. So make sure you stay plugged in with the State Board of Ed. And finally, whether you're wrapping up your day, your week, or you're in the weekend, and you're listening or viewing this professional development, I hope that you have a good rest of your day, week, and weekend. So take care, and we'll see you at the next episode.